All right, thank you guys for joining me today. Today we have a presentation to teach you guys about the role as a chairperson. For our local, we have a couple of different chairpersons. We have the general chairperson and the vice chairpersons. And we're going to explain what those are today. So the chairperson, they're a leader. They represent members in disciplinary matters. They negotiate the contract. They have a direct relationship with members and management. They enforce the contract by filing timely grievances, which we'll explain a little later on this presentation. And they're the voice for all the members. The chairperson has the influence to bring life to the organization's story, values and missions in a way to build strong emotional connections within the membership. So the chairperson is also an organizer for our union, which means that they develop the active union members. They try to figure out ways to include them in everything that we do for the union. We develop the newly hired employees. We have orientation where we get to talk to them about the importance of our union and how to get involved. Urge attendance at every union meeting. We're active in the local labor council. What that is basically a bigger network of unions collaborating on issues with other unions that may be the same issues as ours. So it's just building the network around us. Develops the leaders and the locals. It's just basically making sure that the members know they are the union. And we got to figure out ways to include them. So important documents and tips. We get membership contact information. Luckily, there's an assembly bill out there, AB 119, that forces our employer in the public sector to give us everyone's phone number and contact information basically every 4 months, I believe, whether we ask for it or not. So that makes sure that we have direct access and ways to contact you if needed within the membership. We got to learn the workplace rules and handbooks. The reason is because we represent you in disciplinary matters and we need to know the rules that we're going into there to these meetings to protect you. We got to obviously know the collective bargaining agreement because we got to protect it, right? We got to save all of our notes and files. You never know when we're going to need it. Put a date on everything so we know when those notes were added. And basically, as a chairperson, you're equal to management as a union rep. You have the right to investigate, say it's whether it's disciplinary matters or a grievance, which is a violation of our contract. You have the right to request information. You get to challenge unilateral changes, which means that the employer decides to one day change something within the working conditions without consulting the union. And stand up to the boss. You are equal to management as a rep. And this book, The Legal Rights of Union Stewards, is a great book to read to learn about your rights as a union rep. There's the link where you could actually find it on Labor Notes. The interesting thing about these books, if you look it up online, it's really difficult to find, but if you look through it through Labor Notes, it's $20 or less. Pretty good books. So going into what is a grievance. So what is a grievance? A grievance is a complaint of a violation of the following: the collective bargaining agreement, also known as our contract, federal or state law, an established past practice, or an alleged violation of a work rule or policy. Basically, a yes to any of these is a grievance. So who protects the contract? The general chairperson does, the vice chairpersons do, but most importantly, the members do. The only way chairpersons know about violations sometimes is when the members bring it to their attention. They are the everyday guardians of our contract. And if we don't know if there's a violation, there's no way to file our grievance. So although we share the responsibility, the members are the everyday guardians of our agreement. So the grievance procedure, basically, when we see a violation, we request an informal meeting with management. We tell them about the violation and we see if we could resolve it that way. Sometimes it's accidental or sometimes it's intentional, but we have an informal meeting with them first. If we can't come to a resolution, then we start taking formal steps. Don't know why I jumped like that. Which is basically a first level hearing, which is basically a hearing officer, which is a manager at Metro, and a representative from Metro, and as well as a chairperson. And we discussed the merits of the case and whether it's a violation or not. If we could come to a resolution, then it's done, and it doesn't go any further. If we can't come to a resolution, then it goes to a second level, which is a hearing officer with a different manager, which is still internal here at Metro. And if we still can't come to a resolution, then we go to binding arbitration. Basically, we submit it to a judge, a third-party, unbiased person that has the authority to make a decision on our dispute over our contractual language. And you can find this grievance process in Article 17 in our contract. So how do you file a grievance? If a violation has occurred, gather all information pertinent to the violation, contact your committee of adjustment representative as soon as possible, because there are timelines. 20 business days is what we have to file this grievance. So if it happened, we need to do the investigation prior to doing so we could see if it's something worth filing a grievance over. Process the grievance through the collective bargaining agreement's grievances procedure, which I explained to you, the first and second level hearing before arbitration. And what is a violation of the collective bargaining agreement? These things could include language over wages, working hours, working conditions, vacations, holidays, benefits, disciplinary actions and procedures, basically any violation in your collective bargaining agreement. So what is a violation of a past practice? A past practice has three categories: contract clarifying, independent, and conflicting. The difference between these is, say the contract is silent on a certain issue, and a no contract is going to spell out every single working condition, but there could be established past practices. And so if we have a certain past practice, we will file a grievance if Metro or employers unilaterally decide to change it. A contract clarifying means that it's over language that's pretty vague. Independent means that it's basically something that's not in the contract. It's not even there. It's something that we're trying to figure out what the practice has been for a long time. And the conflicting one is the hardest one to defend, because it's basically language in our contract. It's a practice that's completely different from the language that's in the contract. So that's a violation of a past practice. How to prove a past practice is that you need longevity, repetition, consistency, and knowledge of and accepted by both the management and the union. Longevity is typically around 2 years in effect. Repetitions, it should occur more than just a few times, and it should not be restricted to one employee. Consistency, that means it happens the same way every single time, and just basically showing proof that both parties had knowledge of this. So what is a violation of federal or state or even local law? We got our Occupational Safety and Health Act, known as OSHA. The Family Medical Leave Act, we know it as FMLA. The Americans with Disability Act, ADA. Title VII of the Civil Rights Act of 1964. Fair Labor Standards Act of, we know it as FLSA. Many more. There's so many labor laws out there, so we recommend getting the labor law source book from Labor Notes to find out what these federal and state protections are. You could actually find this at the fixed route operations behind the supervisor's door. Every employer is forced to post most of these labor protections on the wall, so go look for it. So what are the 6 W's when investigating a grievance? Who are involved? What is the violation? When did the violation occur? Where did it happen? Why did it happen? And what is the remedy? So arbitration. The arbitrator's authority does not exceed the power of our contract. Arbitrators look for clear language and the intention of the language. If it does not make sense for the arbitrator, they may request the following: proposals from negotiations when the language was added into the contract, testimonies, counter proposals, transcripts from negotiations, notes from negotiations, a past practice to see what has been accepted before. That's why it's so important for us to save all of our notes from every contract negotiations for our contract. Disciplinary representation, known as just cause protections. What is just cause? The great thing about being in a union is just cause protections. Just cause forces your employer to have a reasonable and lawful ground in order for them to discipline you. Workers without a union can be fired for any reason because they are at will, which means they can be terminated at will. So the steps for the disciplinary process in our contract with Metro, you can find this in Article 16 and Article 18 in our contract. So the first step, say an incident happens. It could be something that happened in the bus or something that you did. An incident happened. Metro now has 20 business days to give you something called a notice of intent. And in between then, investigatory interview that they're going to have with you to ask you questions about that incident. Give you a chance to explain yourself. See if you're going to lie about it. Most of the time they have footage about it already and they just want to see what you're going to say. The notice of intent is a document that they give you, which I'll explain in another slide, that basically explains everything and why they're planning to discipline you, their recommendation for the discipline. It will have their statement, it will have their evidence, it might have footage, it might have a bunch of things. But you're entitled to due process, and I'll explain it. So once we get the notice of intent, if it's a suspension or higher, which could be termination, you're entitled to automatically the first level hearing. That means that Metro can't even impose that discipline until you go through the due process, which means we have a first level hearing. A C of A officer, myself, Brandon, and it could be any C of A officer, could go in there and represent you as if we're your lawyer to speak in your behalf and defend you, and we go off of the notice of intent. If we see flaws with the way they gave you that discipline, or maybe they didn't follow the just cause procedures, we'll go in there to defend you and make sure that they either drop the charges, reduce them, or figure something out. If we can't get the decision that we like, because the hearing officer's got to give us a decision letter within 10 days after that hearing, which is basically a Metro manager that's listening to both sides make these arguments, then we get to appeal it to a second level hearing. A second level hearing is going to include a hearing officer that's a different manager for Metro. And we're going to present the same case or maybe additional evidence, but it's the same representative for Metro coming forward with the charges, and your representative with the union, typically a C of A officer. And say we get the decision letter 10 days again and we don't like the decision that the hearing officer made, then we appeal it to arbitration. As we explained earlier, arbitration is a third-party judge that comes in to make the decision for us. So the investigatory interview. Everyone should have one of these cards to have a reminder of what to say if a supervisor brings you in to talk to you by yourself. You're entitled to something called the Weingarten right, which means that if they plan to talk to you, you could ask them, can any questions that you ask me could lead to discipline? And if they say yes, you have every right to stop them and ask for a union rep. This is a way of saying it if you wanted to read it off the card. If this discussion could in any way lead to me being disciplined or terminated or affect my personal working conditions, I respectfully request my union representative, officer, or steward be present at the meeting. Without representation, I choose not to answer any questions. And the reason why you want to do this every single time when you think that it might go to discipline is because we are a witness. We go in there and we take really good notes, and if we need to get involved, we will. So it's a good habit of exercising this right, no matter how small or big it might be, because we have seen it to where members' words are twisted in meetings without a union rep. These cards can be requested from Smart TD. We do have some in the office, so if you don't have one, come and grab one. Important factors of Weingarten rights. Unions can ask for the specific charges being investigated. Management does not have to give away the entire case, but must provide at least a general description of what's going on. Union representatives can insist on a private consultation or caucus with the employee before questioning begins, just to talk to them about how they should approach this. The representative can advise the employee on how to answer particular questions. Representatives can take notes. The representatives can object to harassing or confusing questions. However, they cannot repeatedly interrupt, abuse the interrogator, or attempt to turn the meeting into a debate. Management has the right to investigate, misconduct, and employees have the duty to cooperate. Interrogator refuses to reveal the matter being investigated or allow a private consultation caucus, the representative can advise the employee not to answer. So the notice of intent, what I was talking about earlier, this is what it looks like. They'll have the date to the person, the employee number from the subject, the case number, the hearing date, and the recommended discipline. They'll have their charges, which is usually a statement. They'll have violations. They'll have the evidence, supporting documents, everything, their case, why they're doing and why they came to that decision for the recommended discipline. So we do have a saying in the union: we work now, grieve later. Insubordination is grounds for termination. So this is how management describes insubordination. Insubordination is a deliberate and inexcusable refusal to obey a reasonable order which relates to the employee's job function. Employees may not decide for themselves which instructions they will follow and which they will not. Always work now, grieve later. The only time you could ever refuse an order is when it clearly jeopardizes your health and safety. So say it is a violation that they shouldn't be telling you what to do because that's not within your job description. You do it if it doesn't jeopardize your health and safety, and then we grieve it later, because then it would give you grounds for insubordination. So the 7 principles of just cause: there's got to be a fair notice, there's got to be prior enforcement, there's got to be due process, substantial proof, equal treatment, progressive discipline, and mitigating and extenuating circumstances. Basically, Metro has to follow all of this in order for them to discipline you. So what is a fair notice? An employer may not discipline an employee for violating a rule or standard whose nature and penalties have not been made known. Fundamental fairness prohibits an employer from punishing an employee for violating a rule or policy that the employee is unaware of. Employers must publicize standards and handbooks on bulletin boards, through the internet, or by direct announcement. Penalties must be identified, especially suspensions or discharges. The prior enforcement. An employee may not be penalized for violating a rule or standard that the employer has failed to enforce in a prolonged period. When management tolerates infractions for several months or longer, employees are lulled into believing that the rule or policy is no longer in effect. Due process. An employer must conduct an interview or a hearing before issuing the discipline, must take actions promptly, and must list charges precisely. Once assessed, discipline may not be increased. Due process is a legal term for procedural fairness, is implicit in the just cause standard. A paramount obligation is to allow workers to tell their side of the story before the employer makes the decision to take action. They got to have substantial proof. Charges must be proven by substantial and credible evidence. This could be footage, this could be testimonies, they could be a lot of different things. Because livelihoods are at stake, disciplinary decisions must be based on reliable evidence, not rumors or speculation. Arbitrators typically use these 3 standards to decide whether the burden of substantial proof is met. Something called beyond a reasonable doubt, or clear and convincing, or preponderance of the evidence. Those are the layers that they use to determine whether the evidence or substantial proof is met. Equal treatment. Unless a valid distinction justifies a higher penalty, an employer may not assess a considerably stronger punishment against one employee than it assessed against another known to have committed the same or substantially similar offense. Favoritism and discrimination are incompatible with just cause. Employers must treat every single employee who commits the same or similar offenses essentially alike. So what we'll normally do when somebody's facing discipline is request information on what has happened for those certain violations to determine what the level of discipline is applied for that certain situation. Progressive discipline. When responding to misconduct that is short of egregious, an employer must issue at least one level of discipline that allows the employee an opportunity to improve. The objective of a workplace penalty should be to correct conduct, not just punish or humiliate the employee. If a possibility exists that an employee can be rehabilitated, The employer should apply the lowest penalty that is likely to convince the employee to refrain from committing another infraction. So the Metro contract, something that you should know is that a 3-day suspension or less on your record, it stays on your record for 1 year for progressive discipline purposes. A 5-day suspension or more on your record for 5 years. And it usually starts off with verbal warning, written warning, which is letter of reprimand, suspension, then termination. Mitigating and extenuating circumstances. Discipline must be proportional to the gravity. Go ahead.
It's a verbal warning the same as a written warning, or no?
No, it's not. So verbal warnings for us typically go into this booklet that they keep track of, and they'll write a little note in there that they talk to you about a certain issue. Right. And then the next one's a letter of reprimand, which is actually on your record for a whole year, and it's written with the charges and everything why they came to their conclusion. So it is a step above. Discipline, so back to mitigating and extenuating circumstances. Discipline must be proportional to the gravity of the offense, taking into account any mitigating or extenuating or aggravating circumstances. In addition to the seriousness of the infraction, an employer must consider any mitigating and extenuating circumstances that reduce the likelihood that this offense will be repeated. Aggravating circumstances may also be considered. So for example, say a driver had a habit of doing something wrong for a while, and Metro admitted that that driver needs training, and Metro never provided training to that driver, and then the driver continuously does it. Now Metro's on the hook because that's a mitigating factor for Metro to not provide training to that driver when the infraction was violated again. So they could be held accountable through this mitigating and extenuating circumstances as well.
So within what time frame? So the incident happens,
Right.
no training happens for I don't know how long, and then something else may happen. So is there a time frame that Metro has in order to give this person the proper training?
I would say this as soon as possible. I mean, if they don't provide training at all, that's an easy argument to make, is that they admitted that training is necessary and they don't provide the training. If they did, maybe the infraction didn't happen again. So it's just an argument that we can make.
Or the infraction happened again within a short time frame.
Right, and they didn't provide the training. So the 8 tests of just cause. Is there a rule? This is what we go by to see if there's a violation of the 7 standards of just cause. Is there a rule? Did the grievant violate it, which is the member? Was there a notice of the rule? Is the rule reasonable? Was the rule applied unreasonably? Was there a fair investigation? Equal treatment with others? And is the discipline unreasonable? Those are questions we ask when it goes through the disciplinary process. So going into the must-read union book, our contract is the #1 union book to read. This is the fixed route contract, and here's our paracruise contract. The collective bargaining agreement is the #1 union book to get yourself familiar with. But there is other books and videos to learn more. Here is the Guide to Winning Discipline Cases by Robert M. Schwartz. You can learn about these just cause standards in more details. It's a great book for you to buy. You'll learn a lot from that one. There's the Legal Rights of Union Stewards. I'll provide the links right here. There's the FMLA Handbook. There's the How to Win a Past Practice Grievance. No Contract, No Peace. And the Labor Law Sourcebook that we provided earlier. These books right here will teach you so much about what we're presenting today. And that's basically it. That is part 1 of our C of A training that teaches you a little bit about the grievance procedure and the disciplinary procedure.